Well, thank you very much. I appreciate the kind words. Welcome everyone to our seminar here today on a topic that I really like is the concept of employment handbooks. They are something that I prepare a lot of, and I also counsel clients on how to do it right, and also reviewing handbooks to make sure that they're being done right. So that's what the seminar is about today, which is, if you either have a handbook and you want to make sure that legally your handbook has been properly done and won't get you, the employer, in too much trouble, and if you haven't, you're thinking about maybe putting one together, and you want to make sure that you do it correctly so that you protect the company from any sort of legal problems, associated with employees who may try and enforce policies or claim certain rights, under the handbook. So with that, let's turn directly to the handbook issues themselves, and what I'm going to try and do, because we are, frankly, because we are in, and I assume many different places are in different states with regards to these types of policies. We are, I think, in for me, what I'm going to try and do is I'm going to try and hit on some very, general concepts which I think apply to just about all handbooks. And, I'm going to caution everybody that, there are many different laws that affect how you put a handbook together. Some are federal, some are state, and, frankly, they can be, sometimes they conflict with one another. So it's important that when you are putting a handbook together, that you know what the laws are that affect your jurisdiction. So with that, let's turn to talking about some very specific components of the handbook, and how I go about helping clients with these types of issues. So why am I? Unfortunately, I seem to have frozen up here, and I don't know why I've frozen up. All right. Sarah, if you're there, any advice? I can't move my slides. Should I just close it up and then move forward and get it back up again? All right, you know what? I think that's what I'm going to try and do here. So if you can just bear with me for 1 minute, let me see if I can go back into this. And, unfortunately, my whole computer seems to have frozen. Okay, let me see what I can do here. All right, let me see. I'm going to try and go back in here again. So my apologies. I don't know why my computer wasn't cooperating. All right.
I don't see the slides moving here.
Okay, well, you know what? I just went out and I came back in. So okay. Let me see. Here's what we will do. We will jump in where we left off, and I still think we'll be able to cover this within the 1 hour the time allotted. So let's jump on to it now. All right, frequently asked questions. These are things that I get a lot of when I talk to the clients regarding the handbook topic. I get one question that I commonly get is that, I have a company that's never had a handbook, and they say, why should we have one now? And then the other question that I frequently will get is, well, we have a handbook, so when is the best time to review it, update it, scrap it, start a whole brand new one? How do we go about addressing that? So the first question: why should a company have a handbook? Well, there's so many good reasons to have a handbook. Merely because you haven't had one in the past and you haven't had issues, I wouldn't use that as a deterrent to thinking about implementing one now. So why is it a good idea to have a company handbook? Well, for one, it makes it easier for you, the employer, to communicate necessary information to your employees about your policies and about the expectations that you have for them as employees. It also provides potential protection against possible lawsuits. One thing that it can particularly guard against, especially now in the age of the Me Too movement, is harassment claims. Under federal law, if you have a harassment policy and you follow it and you train employees about that policy, you, the employer, can basically generate a very strong and foolproof defense to a harassment claim. And then finally, well, a handbook's a good thing to have because instead of having all your policies strewn around in different places, a handbook gives you, a document, a book where all of your policies are collected, so that people can find the policies when they need it. And sometimes there are policies that are required by law that you can certainly give to employees. You can hand employees the policies out, but it's good to have everything in one area so you know where it is, so that if there are any questions, you can go there and hopefully your questions will be answered. So when should an employment handbook be updated? Well, generally what I usually tell employers is that it's good to have legal counsel review your handbook every year to year and a half, as a general rule. If you know that there are significant changes in the law in the offing, that's also a very important time to check your handbook to make sure that your handbook meets those requirements. Now, I happen to practice in New Jersey, and over the last several months, we've had several significant new laws be passed, one of which requires employers to provide employees with a certain amount of paid sick time per year. And so what I have been doing, a lot over the last few weeks is reviewing handbooks from clients and policies to make sure that the policies meet the requirements of the new law. So anytime you have a significant change in the law, that's an important time for you to go back to your handbook and look at it, and where necessary, have a lawyer take a look at it and get some sort of legal review done. So the nuts and bolts. What are the necessities of a handbook? These are policies that I have in every handbook. And if the policies aren't in there, there's something that I specifically will recommend to my client to get put into the handbook. The first thing, and one of the most important parts of the handbook, is what we call an at-will disclaimer. Now, an at-will disclaimer, what it basically does is it alerts employees to the fact that the handbook is not a contract. So nothing in the handbook binds the employer's hands. And that's one of the big, excuses, maybe that's not the great word, but one of the big reasons why employers who don't have handbooks don't want to create one, because they're afraid it's going to tie their hands, and they're not going to have the flexibility that they like in running their business. If you have an at-will disclaimer, then you don't lose that flexibility, because the disclaimer tells employees that the document doesn't create an employment contract, and it also reinforces and reiterates to the employee that their relationship is employment at will. Now, for those of you out there who don't know what at-will employment means, it basically means that the employer has the right to hire and fire an employee at any time for any reason, with or without notice, provided the reason isn't one that's made illegal under a specific statute, such as, the civil rights laws or the Age Discrimination in Employment Act law. Reciprocally, under the at-will doctrine, employees also have the right to leave at any time for any reason, with or without notice. So it's kind of a two-way street. So the disclaimer also has to alert employees to the fact that, they are at-will employees and explain in very simple, non-legalese language that what that relationship means. If you do that, then you can avoid the potential for having an employee argue to you that what you say in the handbook creates a binding contractual commitment on the part of the employer. Now, some other important things to remember and to do regarding an at-will disclaimer. You want to make sure, and this is something that's required by New Jersey law, but I think it's something that's really good practice to have anywhere that you have a handbook. You want to make sure that your at-will language and your disclaimer stands out and is clear and conspicuous from the remainder of the handbook so the employee knows that, what they're going to be reading doesn't create a contractual relationship between them and the employer. Now, what I typically require and suggest is that the disclaimer be at the beginning of the handbook on a separate page with no other policies on it. And what I also do is the handbook is in a different type of, like text, where it might be in bold, or it might be underlined, or it might be in italics. It stands out from the rest of the book because I want employees to know that this is a special component of the book that they need to focus on. Now, during the Obama administration, the NRB was closely scrutinizing at-will disclaimers. They were particularly finding certain disclaimers that had language that said that there could, under no circumstance, could the at-will employment relationship be changed. And some disclaimers had that language in it. And the National Labor Relations Board said, no, you can't include that because that violates Section 7 of the Act, i.e. it interferes with the ability of both unionized and non-union employees to basically exercise the rights that they have to maybe collectively organize as allowed by the labor laws, because it's deceptive to employees. It's misleading because employees can certainly change the at-will relationship by unionizing and by entering into a collective bargaining agreement. So the court felt that type of language chilled the exercise of those types of organizational Section 7 rights. So be aware of that you really shouldn't have that in your disclaimer. I mentioned here one policy that we're going to talk about is whether or not you want to have a social media policy. You don't want to have a social media policy. The social media cases that came down from the Obama board were very, very pro-employee. It was very hard for employers to properly draft a social media policy to the point where some employers actually they just decided not to have a social media policy. So, I think it's something that we want to, I think collectively be aware of anytime we're putting a handbook together, especially when you have a client who wants to include a social media policy in it. We'll talk about my feelings on whether or not it's appropriate to have one in a bed. The next necessity of the handbook, it's the acknowledgement form. Well, you want to have an acknowledgement form, and I usually include it as part of the handbook that you can just rip out or, it's a standalone signable document because you want to have a record that the employee received it, right? Now, what should the handbook acknowledgement form say? Well, what I typically do is on the acknowledgement of receipt form, I specifically include language that reiterates what the disclaimer says. So I have my at-will disclosure disclaimer language on my handbook so the employee can't claim later on that, oh, well, I didn't know that the handbook was a contract because I never read the disclaimer. Oh, now you got the disclaimer. on the first page of the document, of the handbook itself, and now you have the disclaimer again on this particular document. I think it's a great idea because you'd be amazed at the number of cases that I've litigated where an employee will say, oh, I didn't get a handbook, or I didn't understand the handbook. That is, frankly, one of the main reasons why I get my clients to get these, because if that ever happens at a deposition, I can hand it to the employee and say, look, you signed this document. And another thing that I included in my acknowledgement form is I put in there that, some real good language about you were told to read it, you were told that if you had any questions, here's where you needed to go to have those questions answered, and if you don't understand something, you're really encouraged to let us know you don't understand it, so that when they come back and say, oh, well, I didn't understand it, well, all right, well, you signed a document that said, if you didn't, here's what you're supposed to do. It's a great way to really hit an employee who tries to claim the lack of knowledge defense, to counter that if you're ever sued by an employee thinking, oh, I'll be able to just forget what I did and ignore it, and nothing bad's going to come about it. Well, this is a great way of guarding against that possibility. The EEO policy, and most people, you probably see it in your handbook and you gloss over it, and you don't think it's that important of a policy. Well, it is. And the reason it is if you ever do get sued for discrimination, it's a great policy to show to somebody who's claiming discrimination in a lawsuit, because what the EEO policy does is it basically tells all your employees that you're going to make workplace decisions free of discriminatory considerations. It reiterates your commitment to provide a workplace free of wrongful discrimination, and you're in the policy, you outline, all the protected classes so that employees know that you know what the obligations of the law require. And it's a great tool that you can use in defense of a possible discrimination lawsuit. Now, what I typically do when I write these things is I make them very broad. I include language that specifically says, not only what the categories of protected classes are, but I also have some catch-all phrases and any other classes under any federal, state, or local laws. Some state laws are different than federal law in terms of the expansiveness of the protected classes. Also, some local municipalities have their own EEO laws. So I want that to be covered as well in the policy. There are certain exceptions that an employer can utilize in terms of not having to follow those laws, and I'll usually mention it. For example, when you have like an opportunity for a bona fide occupational qualification defense, I usually like to put that in there. For example, a bona fide occupational qualification defense. If you happen to be, you want to be a priest in the Catholic Church, you have to be of the Catholic religion. That would be a bona fide occupational qualification. And then I also like to mention in the EEO policy that the employer is committed to make reasonable accommodations per the disability laws, the anti-discrimination laws, particularly the ADA, the Americans with Disabilities Act. And I also usually put in there, so long as it doesn't impose an undue hardship on the employer. This is a policy, and here in New Jersey we call it a SEPA policy. It's a whistleblower policy, and I cite this because there are some states that have very specific notice requirements for particular kinds of laws, and the SEPA law here in New Jersey is one such law, and it's basically it's a reminder to employees of what their rights are under the SEPA law to be free from retaliation for engaging in whistleblowing activities. Some states have similar requirements. You want to check your state to determine whether or not you have any types of those policies where it's a necessity because the law says you have to include notice of the law in a handbook or in any type of policy manuals for your employees. The big one, obviously, is the anti-harassment policy. It's something that every company should have, even if you don't have a handbook. It lays the foundation for getting the defense that's made available to employers under two U.S. Supreme Court cases that came down several years ago, the Farragher and the Ether case. There's also some states that recognize that defense as well. Flowing from the anti-harassment policy, New Jersey is one such jurisdiction. So you might want to check with your jurisdiction that you're in, because that may be another incentive for you to have one of these policies. Your anti-harassment policy should be a strong run. It should be proactive in preventing and responding to workplace harassment claims. It has to be enforced. It's got to be more than a mere sheet of paper. Because if it's not enforced, you're not going to get the defense. You want to send a really strong message against harassment in the workplace. In no uncertain terms, you want to specifically indicate that the company as a whole is strictly against any sort of harassment. And you want to include a broad definition of what harassment is, and you also want to include in there that harassment isn't just sexual harassment. It's any type of harassment that flows from being a member of a protected class under the EEO laws. So my anti-harassment policy is very strong. It says this company will not permit any sort of harassment against employees for any reason that's prohibited under the EEO laws. You want to have a very strong statement that harassment is strictly prohibited, that violations will be subject to discipline. You want to have an effective and reasonable complaint procedure that actually makes it easy for a person to step forward to report policy violations. You don't want to make it too hard for them. You want to have you want to have a procedure, and then you want to have kind of an alternative route just in case the person who you identify in your main procedure happens to be the harasser. You want to include confidentiality restrictions so everybody knows that the process is going to be confidential. You want to basically remind employees in your policy that there's no retaliation for using it. And if there is retaliation, there will be strong discipline imposed against anybody who retaliates against an employee who uses the procedures to report harassment. And then you also want to cover special circumstances. We have the concept of third-party harassment. Employees, because you, the employer, have to provide a workplace free of any sort of harassment, includes an obligation to make sure that people who come to your facility, that if they are doing something inappropriate and harassing your employees, that you are going to protect your employees from that sort of harassment, and that employees are going to have an avenue to complain about it so you can take corrective action. And if that means you have a multi-million-dollar client who comes in and is very fond of your receptionist and is unwilling to stop asking her out on a date, guess what? Under law, you have to tell that person to knock it off. And then you also have third-party harassment claims driving from people who may not be actually the target of the harassment, but they're hearing it and it's impacting their environment. It's affecting their ability to work. You want to include that. You also want to make sure that that everybody understands that the policy goes to wherever your business is. So that if you have satellite offices, you want to make sure that they know that the policy covers satellite offices as well as your main office. The next required policy, just like an anti-harassment policy nowadays is required, is a family medical leave policy. Now, this is required for any employers who have 50 or more employees. So my FMLA policy is very detailed and very broad. It's about 3.5 pages or so. It outlines both the employee's rights and the employee's responsibilities, along with the employer's responsibilities and employer's rights under the FMLA. This is something that flows directly from the law and from requirements of the United States Department of Labor to have this sort of policy in a handbook. Now, if you're not covered by the Family Medical Leave Act, there are many employers who nonetheless still want to include some sort of an extended leave policy in their handbooks. And, that's okay, so long as you understand that you're going to commit to it. Now, some employers, when they're outlining the employee rights and responsibilities, they may say that the leave will be granted for a certain amount of time. Or the policy may say that the scope of the leave will be examined and be addressed when the need for the leave arises. So it'll be done on a case-by-case basis. Either way, even if you're not covered by the FMLA and you want to provide those types of rights to your employees, you want to notify them of that fact in your policy. Now, as I said, there are many states that have similar types of laws and requirements as those that you would find in the federal law. New Jersey is one such place. We have our own Family Leave Act. It's a little bit different than the Family Medical Leave Act in that this law doesn't cover somebody's own health condition. But what I typically do is I also, as part of my FMLA policy, I specifically talk about the state law. And I include a provision in there explaining what their rights are under the state law. New Jersey also has paid leave. So if somebody's out on a leave of absence, employees are entitled to get 6 weeks of paid leave. Now that's administered. It's a program that's administered through the state of New Jersey. So I include notice in there, my handbook as well, about those leave rights and those leave obligations. Now that New Jersey has this paid sick law, where you have to provide sick time, that's a new policy that I recommend to my clients, be put into the handbook as well. You want to have all those policies in one place so that if the employee has a question, they can go to there and they can look at it, or if somebody in HR has a question, they can go and they've got a document that will hopefully provide you readily the answers that are necessary to answer the question. So, I cite these laws as an example because these are the laws that I most frequently am dealing with. So when you're putting your handbook together, you want to make sure that you're covering state laws as well on this topic of the issue of leave. An email computer usage policy is a must. Now that we all use computers and everything, or just about every employer has their employees utilizing computers and what they do, or other types of computer devices like cell phones and things of that sort. One of the big things you need to do with an email computer usage policy is you want to make sure that the policy advises your employees that you'll be monitoring the use of the equipment, and you're going to be looking at the communications that are sent over the company-owned equipment. You want to advise people that their use of your equipment constitutes a implied consent to monitor. And what I like to do sometimes is I'd like to get like a separate sign-in or acknowledgement sheet so that the employee signs it and understands what this computer usage policy is designed to do and the impact that it has on their privacy rights, which is they're pretty much it negates any privacy rights. So employees really need to be alerted to that up front so that they don't think that they retain their privacy rights by using devices and computers and things of that, electronic devices that are provided by the employer. Okay. The policy should also explain that the computers are company property. You want to discourage, employees as much as possible, from using your system for private purposes, although it's hard to find policies that outright ban it. An internet policy, you can't use it at all during the day. I think most employers are allowed for some reasonable use, provided it doesn't, interfere with the employee's ability to do their job. And you obviously want to make sure that you explain what types of things are prohibited through the use of your company technology. For example, the policy basically will say you shouldn't be using our policy, our computers to harass people, to defame people, to engage in improper solicitation, or disclose our confidential information to persons outside of the company. And speaking of solicitation, it's also, I think, important to have a no solicitation, no distribution policy in a handbook. Now, you got to be careful in crafting such policies because there are rules on how you do it right, and those rules flow from certain requirements under the federal National Labor Relations Act labor law. Most of the time people have these policies because they want to deter union activity. Now, an employer can prevent solicitation or distribution of literature and like things on working time and or in working areas. Now, you can also prevent same that interferes with other employees' work. For example, the one thing you've got to be real careful about is, if you allow people to bring in religious literature and put it around, or charitable literature and put it around into your forum area, like your waiting area, then now all of a sudden you've opened the door to employees coming in and putting union literature in there too, because you can't treat union literature or union meetings or union discussions less favorably than other types of solicitation or literature. So, what I usually tell employers is, if your goal is to use this policy as a way of deterring union activity in your workplace, you've got to adopt a real zero tolerance sort of policy. HIPAA policies. HIPAA is the healthcare law, the federal law, that does a lot of things. It protects the privacy of medical information, but one of the big things that it does is it guarantees that employees, if they go from one employer to another employer, they can continue their health care coverage and not be disqualified because they have a pre-existing condition. So, I usually like to just mention HIPAA, mention that in the handbook, and for those employers who are covered by HIPAA, and that means employers who are either self-insured health insurance programs, or their health insurance offices, or health insurance providers, whatnot, then I think you want to have a good HIPAA policy that basically tells employees what their rights are, guaranteeing the confidentiality of their protected health information, and also outlining what an employer's obligations are and an employee's rights are in terms of how they protect health information, how employers can disclose it, how employees can prevent the disclosure. And you should also have anti-retaliation and a guarantee of non-use in employee decisions mentioned in your policy. And the guarantee of non-use basically says we're not going to consider your health information, if we have it, in making any decisions that might impact upon your employment. COBRA. Now, if you're an employer and you have in excess of 20 employees, COBRA applies to your operations. And what COBRA does is it gives employees the opportunity to continue medical coverage after they leave, they're separated, they're fired, and they get to keep it for 18 months, and they have to pay the out-of-pocket themselves, and it's certainly more expensive than what they would be paying, just their portion of the premium, if they're working for the company. And what most people don't realize is that under the law, you also have to include, when somebody leaves, I think we all kind of recognize that the employee has to receive notice of their COBRA rights after they leave. Well, you also need to include it while they're employed, when they're first starting. And so you want to include in the handbook a policy that basically just explains that employees are going to have the right to the potential retention and continuation of medical insurance coverage after their employment ends. So you even have to tell them that when it's first starting. Now, benefit summary. What I like to do with regards to a benefit summary is I only include a brief statement of what benefits are offered. And that's going to obviously vary depending upon what an employer is willing to give to their employees. Things like vacation pay, PTO time. Sometimes there's a summary of available health benefits. I really don't like describing in particular, in detail, all the health benefits or other insurance-type benefits that might be available. I like to just explain them generally, provide some general parameters about eligibility. But in the end, there's plan documents. And, the plan documents speak for themselves. And, I'll usually have like a disclaimer in the policy that basically says, obviously, to the extent anything that's said here is inconsistent with the plan documents control, all right? And then, of course, I also like to include just a general disclaimer as well, just to let employees know that the employer has the right to modify or discontinue certain benefit plans. That you know, they have that right, and they continue to have that right, even though they're mentioned in the handbook. Workers' compensation policy. The workers' compensation policy is important because it alerts employees to the fact that such benefits are available. And I think even more importantly, it tells employees the importance of immediately reporting such workplace injuries to ensure that the coverage actually takes hold through your workers' compensation insurance. So the policy will specifically say, hey, if you have a workplace injury, the expectation is that you've got to report it immediately to your manager, or otherwise it could jeopardize the coverage. BYOD policies, bring your own devices to work. More and more companies are starting to adopt such policies as part of their handbooks. You want to make clear what the employer can do in terms of accessing or monitoring what's going on with somebody's personal computer devices of employees. Sometimes these BYOD policies specifically tell employees that they can't bring certain types of devices into the workplace. For example, you know, if you work in a very you work in a factory setting and you are producing, you know, very secretive stuff for the government of the United States, I don't think you're going to want employees to be able to bring phones in that have cameras these days and take photos of things. So you might basically tell employees that you can't bring a device into certain areas of your facility. You may also basically restrict employees from performing work on their devices when you're providing them their own types of computers for that purpose. So, I mean, these policies, I think we're seeing more and more of them because technology is changing, and employees are actually bringing their own phones to work. And so you can guard against certain things by having these types of policies in place so employees know the parameters of what they can bring and how they can use them when they come to work. Some other policies to consider. Now these aren't mandatory policies, but these are policies that we often find in a handbook. The progressive discipline policy. You know, this is a policy where the employer basically says, you know, we're going to follow, you know, particular steps in terms of disciplining employees, and you know, with each particular violation, we're going to work up kind of like this step system, and you know, at the bottom there's less punishment, and at the top there's the potential for firing. I mean, if you're going to have one of these policies, you should really be committed to follow it. Now, for the most part, I don't know, I think more and more employers are getting away from this, having these types of policies, because, you know, they're finding that they have them, but for various reasons they decide not to follow them. And that's because, you know, if you're going to have one of those policies, you need to have a list of exceptions to those procedures so that you have discretion to determine when you want to follow progressive discipline and when certain things would allow you, you know, for you not to follow progressive discipline. And, you know, I think that's, you know, I put a laundry list of things together, the kinds of things that, you know, allow the employer to just forget about what the policy requires and go straight to firing somebody. You know, if you have somebody who's actually assaulted another coworker and physically was in a fight with a coworker and, you know, may have injured that coworker, you don't have to keep them around because the first step of your progressive discipline policy says, well, at this step, you get a stern written warning. No, you can go straight to termination. And, you know, the reality is, I think the exemptions have become so broad that they're swallowing up the whole concept of doing progressive discipline in the first place. Nevertheless, it is a policy that some employers may want to use, may not want to use, and it's something that, you know, is very commonly seen in a handbook. A confidentiality policy. It's a policy that advises employees that they must keep all company information, that is proprietary confidential, and they can't disclose it outside of the workplace. And they also, just as importantly, they are restricted in using it solely for the employer's benefit. Now, under the last board, the NLRB, they took a very, very broad view or actually a more narrow view of what confidential information could be covered by such a policy. I have seen some confidentiality policies that specifically tell employees that information about their wages is confidential and it can't be disclosed to anyone. Well, the NLRB is not a big fan of that type of policy because, one of the things that's important if workers are going to want to exercise their right to unionize is they need to have information about what other employees are making salary-wise, wage information, because that's one of the big things that employees do as part of collective negotiations is to negotiate what wages potentially should or shouldn't be paid. So the NLRB was striking down any sort of confidentiality policies that told employees that they couldn't disclose that information to coworkers. We'll see if that changes with the new board, but be aware that in how you define confidentiality, there may be a need to do so in line with NLRB requirements and NRLA requirements. A probationary period. Now, I think having a period of time where you, the employer, get to know the new employee and the employee gets to know you, and it gives you an opportunity to judge their performance and to see whether or not it makes sense for you to continue with hiring and employment of those people. I think it's great to have. The one thing I don't like is a lot of times they call these policies probationary period. I like to call it an introductory period instead. You don't want to make employees think that by virtue of getting through the period, somehow they gain greater employment rights. Well, they don't. They're still employees at will. So nothing changes that status merely because you get through the probationary period. It just means you get to continue working past the probationary period. Nonetheless, I still think it's a good thing for employers to have. Drug and alcohol use and drug alcohol testing policies. They're very commonly used. I think they're a good idea for employers to have. Some are mandated because there's drug-free workplace requirements. Sometimes there's laws that specifically mandate drug and alcohol testing of certain industries, truckers, pilots, folks of that ilk. And if you're going to have it, and if you're going to do it, you want to make sure that you have a good drug and alcohol testing policy. Now, you want to, as part of the policy, let employees know that there's going to be the potential for drug testing during work hours and on company, you want to let them know that there's a potential for drug and alcohol testing, if certain requisite requirements are met under the policy. You want to include in the policy a very broad statement that basically says drug and alcohol use is strictly prohibited during working hours and on company premises, and that the employer, by virtue of having the test, is assuming the right to conduct testing. Now, what types of tests can be done in a policy? Well, pre-employment can be done legally, and remember, you can only do that after making a conditional offer of employment. Why? Because a drug test is deemed to be a medical test, and under the Americans with Disabilities Act, an employer can only seek and gain medical information about an employee after they've made a conditional offer of employment. Well, a conditional offer of employment is we're offering you this particular this particular position in our company, subject to you passing a drug and alcohol screen. That's the way it's done. Reasonable suspicion is also allowable. That's where you see an employee and you think maybe they're under the influence of drugs or alcohol. My policies specifically identify the types of indicia that might lead an employer to want to do a drug test. Slurred speech, blurry eyes, difficulty walking, smelling alcohol, difficulty with coordination or communication. All those types of things could be grounds to require reasonable suspicion testing. And then there's the issue of random testing, where you just randomly select a certain employee or group of employees for testing on a particular time without any notice, prior notice. Now, here in New Jersey, you can only do that for safety-sensitive positions, and that's the case in a lot of different states. So be aware of any restrictions on that ability to random test. Now, there's some federal laws like anybody who has a commercial driver's license, they have to be made subject to this type of testing. They know that the testing has to occur because legally it's required by the federal government. If you are going to do random testing, you want to let employees know that that's part of your testing program, and you also want to identify what positions are deemed safety sensitive so employees know that they potentially are going to be subject to random testing because of where they are. Your policy should also explain what a positive result is. You want to include an explanation of procedures, possible penalties, and you want to reiterate the confidentiality of results. Now, a big issue now that we're seeing develop is what are employers supposed to do about medical marijuana use, or even in some states recreational marijuana use? Well, there have been cases, decided throughout the country in different jurisdictions, including here in New Jersey recently by a federal court. And employers, if they so desire, they can still deem a positive test of marijuana as being violative of your policy, even if it's medically prescribed. Many places have had this issue come up, and because marijuana is still illegal under federal law, the mere fact that state law has decided to decriminalize it, it doesn't stop an employer from saying, we don't want our employees using marijuana, even if it's medically prescribed. Now, conversely, an employer could also treat medical marijuana like finding Tylenol or any other type of prescribed drug in somebody's drug test. That's something you, the employer, should really decide on as you come up with your program. With that, I told you we were going to get everything in before the hour expired. So it's time for questions. So if anybody has any questions, I guess I'll turn it over to Sarah to orchestrate how the questions get asked.